Very good morning to Dean Knight, Law Lecturer. You have been reading Sir Geoffrey's, I was going to say treatise. This is something he's thought about and discussed and debated and advocated for such a long time now. The book form, written with Andrew Butler, is a constitution for Aotearoa New Zealand. Start with what you see as the most significant proposals.
Well, kia ora koutou. I think the first thing to take away from this project, it is an ongoing project of Sir Geoffrey's, and he's joined with Andrew Butler. It's really quite incredible and ambitious to try and crystallise, revise, and expand our present constitutional, abstract and sort of diffuse constitutional rules and principles, and they need to be really commended for trying to give us and proposing a new blueprint for our sort of civic governance. So actually, that process of collating them together, expressing them in one single document that the people can read, pick up, buy at Whitcoulls or wherever is really, really important, and I applaud them for that.
In simplest form, we don't have a written constitution. We have a series of documents which together essentially form our constitution.
Yeah, that's right. We've got at best we've got a Constitution Act, but it's a sketch, and they fill out that sketch. And on that point, I list the key institutions and articulate their job description, what they should do, interact. They fill it out, and that's great. I love that, and I think that's important. And I think that's a project in its own right, and I think that's a valuable sort of thing to put on the table to talk about. Should we move to that sort of thing? I think the interesting thing for me is the extent to which the second part of the endeavour, which is to tweak some of those existing rules, to add bolt on some extra protections to the political process, the government process, and so forth. Which on that level, again, there's lots of features like some new positions, Judicial Appointments Commission, an Information Authority, a new Human Rights Select Committee. Reconfiguring some of adding. Some more restrictions on the way that government power and parliamentary power is exercised, higher threshold for urgency and so forth. There's lots of sort of like tweaks and bolt-ons and quite a lot of detail that tries to, as they would describe it, put handbrakes on that government power. Again, we've got to sift through these, but by and large, that's a positive sort of addition to our sort of civic governance process.
Let's skip over some of the obvious stuff. The new New Zealand head of state, in other words, instead of the Governor General moving to a domestic head of state, but again in essentially a ceremonial role, right?
Big cheer from me. It's easy.
Next step, Parliament 4-year term, and also a higher hurdle for holding urgency, because urgency's become a bit of a go-to, hasn't it, of late? This is where the Parliament sits under urgency. And things are truncated. And
a lot of people in the field agree with that, so we need more time for government and parliament to get through their business, but we've also got to slow down their sort of their rushing through things as well.
Let's get to some of the other standouts of what is proposed.
Parliamentary sovereignty. Change and the situation where power is going to be located within our constitution, they're looking to reorientate that and move it. And what I mean by that is they're suggesting that there should be higher order or supreme norms or controls or restrictions on what Parliament can do. And by this, the two key areas are an enhanced Bill of Rights with some more rights, but a judicially enforceable Bill of Rights, and also a recognition of the treaty and the treaty obligations, again, together with judicial enforcement, the ability to strike down legislation, at least in the first instance by the Supreme Court, if legislation is inconsistent with those principles.
Currently, we have a Bill of Rights that is, to put it bluntly, routinely ignored. The Attorney Generals will report to the Parliament on parts of law that are inconsistent with the Bill of Rights, and then they go on and pass it. Second point, the Treaty of Waitangi would be elevated to having equal status to other legislation, effectively.
Well, the courts would be able to strike down legislation that
based on inconsistency with the Treaty of Waitangi.
Yeah, although, and I need to pause you and say there, Andrew and Geoffrey are proposing that Parliament has an ultimate override trump at the end of the day if they can get 75% majority to disagree with what the courts have decided. So it's important,
which may actually happen quite a lot.
Well, there's a question of that. But
next point. Is this moving towards a more American system where the Supreme Court can strike down decisions? And is that what you've just said? Ultimately, would Parliament, if it got 75% majority, have a a say over there.
What it's a move away from is our present parliamentary sovereignty, where Parliament has full powers and absolute powers. That's the starting point. How far it moves along that continuum towards judicial supremacy is something on which people will disagree about. About how far it moves and whether that's a good thing, because it does invite the judges to engage in matters of public policy, economic and social problems, and to adjudicate and express views on whether they are consistent with the right to privacy, the right to property, the right to free education, and the right to right to against unlawful detention, and legislation would be able to be struck down by the Supreme Court if it's inconsistent.
What are they wanting with this? It's not so much a provocative book to start conversations. They're actually putting it out in draft form, aren't they? And wanting submissions and wanting response?
They've made a decision. It's a consultative draft. They're inviting submissions from people who are interested. They're going around the country having meetings and town hall meetings on this sort of thing. But it is their consultative draft. They decide to sort of lob something tangible into the constitutional conversation. We've had previous attempts at trying to revise our constitutions which have just fell flat because there's been nothing tangible on the table. And they've said, we've got a model, rightly or wrongly, this is our model. Tell us what you think. The question for us is, I think, do we like it? And what bits do we like? What bits are fundamental in their model? What bits might we want to tweak? And they're inviting submissions. Where does it go from there? It's really dependent on whether the political, social, polity actually want to pick it up and run with this style and model of constitution. It's an important one. It's an interesting one. It's not the constitution I think Māori would come up with, and I think there's a question mark. Although the treaty is elevated, I think it's not the starting point for Māori to have what is a very traditional, orthodox constitution, expressed in traditional way with traditional power structures and the borrowing of constitutional provisions from Canada and Samoa and other places. So I think there'll be some nervousness about where this constitution started, and people want to start in different points. But what it does do is it does allow us to look into this question of blueprint for public governance and ask the question of, have we got it right?
Readable for substantial subject matter.
Incredibly readable. There's 43 pages of the text of the Constitution, and that's reasonably accessible. But there's a chapter by chapter they go through and identify the different problems and issues in our Constitution. So constitutional learning about how it works, but also explaining and narrating what they're proposing.
And some Tom Scott cartoons, which are always welcome.
Oh, great cartoons.
Thank you very, very much. A Constitution for Aotearoa New Zealand by Geoffrey Palmer and Andrew Butler is published by Victoria University Press. The recommended price $25.